Hello, this is Tim Semmelroth, and in this recording, I'm going to talk to you about how to write your closing argument. So the first thing to understand about a closing argument is that this is the time when you're trying to persuade the judge that your side should win. And so you need to think about that when you're writing your closing argument and also when you're presenting it. So again, just like with the opening statement, there are specific sections that we want you to use. We want you to use a particular outline when you're writing your closing argument. So let's get to that outline. The first step is to do your introduction. And this is where you are reintroducing your theme, the theme that you started using in your opening statement and hopefully carried through with some witness testimony. And then you're reminding the judge of your theme, what the big idea of your case is. You want to make sure that you don't start with boilerplate. You don't want to spend a lot of time saying, thank you for your attention today, or you want to get right to it, get right to your theme and get into your argument because you don't have that much time. You have 8 minutes to give your opening statement now, or your closing argument. So if you are on the plaintiff side, really you only have about 5.5, maybe 6 minutes to do your initial closing because you're going to need to save the last couple of minutes for your rebuttal. On the defense, you've got the full 8 minutes to use. So after you've done your introduction, the next step is to outline the rules of decision. So that means you want to remind the judge of the burden of proof, and you want to remind the judge of the elements, the different questions that the judge needs to answer that you have been helping them answer during the course of the case with the evidence and testimony that you've offered. So you want to make sure that you touch on the rules of decision, so the burden of proof. So as Your Honor knows, this is a case where the plaintiff is claiming that the defendant was negligent. Because of that claim, we're going to be proving our case to you today, or we proved our case to you today by the preponderance of the evidence, the greater weight of the evidence. And let's talk about how we did that. So that's an example of section number 2, outlining the rules of decision. One important thing that I want to mention is you're always talking about this in terms of past tense. Remember, the evidence is already in, the testimony, the exhibits that you've offered into evidence. And so it's not that you will prove anything. At this point, you've proved it, and you're just reminding the judge how you proved it in your closing. Okay, the next step is to go through each element or each question and explain how it has either been satisfied, if this is a question that your side has the burden of proof on, or how it's not been satisfied, if it's a question or an element that the other side has the burden of proof on. And you're going to explain how it's been satisfied or not satisfied by referencing the evidence, the exhibits that have been offered, and the testimony that's been provided by the witnesses. So you want to organize your argument by these legal questions, the legal elements. You don't want to organize your argument by the order of the witnesses. You're not going to get up and say, okay, let's talk about what each of the witnesses said. That's boring. You want to say, these are the questions you have to answer. Let's talk about why you should answer the questions in this way. Now, once you've explained how each of the questions should be answered, you're ready for your conclusion. So you're going to restate your theme, and you're going to tell the court what you want it to do. So if you're the plaintiff, you want to tell the court that you want that's why now at the end of trial we come to you and ask that you find in favor of the plaintiff, or if you're on the defense, you're asking the court to find in favor of the defense. So let's go through some tips about how to write a good argument. First of all, don't spend too much time telling the judge the law. It's always a mistake to recite long sections of the jury instructions or long sections of the Iowa statutes. That's boring. You can just reference it. The judge is supposed to know the law, so you need to talk about it, but you can summarize it. You don't have to recite the whole law. You don't have to cite different code sections. You can talk in more general terms. You also want to take the time in your argument to remind the judge about the most important images from the case. And so those are the stories, the exhibits, the things that evoke the strongest emotions. Because remember, the closing argument is an argument. You want to be making an emotional appeal. Another tip is you want to try as best you can to refer to specific quotes of the witness testimony. So you want to say things like, "We heard today from this witness who said da 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 da." You don't want to rely on general statements like, "Hey, we just proved this to you." Reference as specifically as you can the witnesses who gave the testimony that help your case and help the judge answer each important question. You also want to try to refer to specific exhibits as much as possible. And if you can, you actually want to hold them up and refer to them by exhibit number. If you can do that a couple of times in your argument, that's going to be impressive to the judge. And you always want to point out the flaws in the other side's case. So you want to be thinking about what are the contradictions, the fallacies, the leaps in logic that the other side makes. You want to remind the court that it can use its common sense when answering these questions. Now, this isn't going to apply as much in the kind of Zoom trials that you're going to be doing this year, but you always want to take down the other side's visuals when you're actually in the courtroom with them before you begin, unless it's a rebuttal, in which case then you're going to want to twist their visual if you can, and that may be a situation where you want to keep it up. You also want to make sure that you have the judge's complete attention. So you want to make eye contact with the court and wait for total attention before you start saying a word. It's really important, as I've mentioned before, that you argue your case with passion and energy. If all other things are equal, the person that seems like they want it more, that they're putting more of themselves into the argument, is going to be the person who scores better. It's important that you don't start arguments or sentences in your arguments with things like "I think" or "I believe." In law school, lawyers are taught it doesn't matter what you think or what you believe, it's what the evidence and testimony shows. So you want to talk in terms of the evidence and testimony, not your own personal opinions. And if possible, you want to show something new in your closing argument. There's a good chance that the judge who judges your particular trial will have seen this trial before with other teams doing it. And so you need to ask yourself, how can we show them something new? How can we give them an analogy or a visual aid that they haven't seen before that is going to be novel and make your argument stand out compared to any time that they've heard this case argued before? Remember, for the plaintiffs, you have a rebuttal after the defense closing. And that is a time where you get to respond to the defense closing. Now, it's something that you're going to prepare probably a couple options in advance, but ideally it's going to be something that seems like you are responding directly to what the defense said, and that you're somehow, that you're thinking on your feet, you're coming up with a way to respond to their best arguments. So those are some basics about closing arguments. We're going to give you some examples to watch in different YouTube clips, but hopefully that will help you to start writing your closing in this case.